Mr. Cousins, what's the password for the tablet? Mr. Cousins? What's the password for the tablet? Please move me, so you're live on YouTube. We're going to call it device. Good morning. My name is Lonette Lynch. I'm an associate tutor here at the Norman Manley Law School Legal Aid Clinic, and it is my pleasure this morning to introduce our presenter and my friend, Miss Dionne Cruickshank, formidable in her own right, but also following in the footsteps of her late father, the formidable Glenn Cruickshank. Dionne is a tutor and attorney at law here at the Norman Manley Law School Legal Aid Clinic. Dionne has practiced at the private bar, both civil and criminal litigation. She has over 20 years experience. She looks young, yes, over 20 years experience, and is also a trained teacher, having also taught in England. Her students here at the clinic describe her as a very patient and passionate tutor who is also willing to share her knowledge. They also say she's no nonsense. I turn over now to Ms. Cruickshank to share her extensive knowledge with us. And for viewers online, please put your questions in the chat and we will address them at the end of Dionne's presentation. Thank you.
Good morning again, and welcome to our fourth day of the Norman Manley Law School Legal Aid Fair. This morning, we are going to address the matter, submit case done. And we're going to look at what happens if a matter which is brought before the court has been adjourned, sine die. Now, what does sine die mean in English, as it is a Latin term? Sine die occurs at the end of a trial or purportedly an end of a trial of a case without designating any future date. And we're now going to look at why this has happened and how does this happen? And what are the results of a matter that is adjourned sine die? If a matter is adjourned sine die, it is of a great disadvantage to the accused as it offers no finality of the litigation. How does a matter before the court get to the stage of sine die? So a matter is before the court, adjourned sine die, there is no finality to the case. When a matter is before the court, we have various persons. We have the adjudicator, who is a judge, a clerk, a prosecutor, defense counsel, a complainant, and an accused person. So the complainant is the one who first attends the police station and makes a complaint against the accused person. The accused person is then interviewed, charged, and brought before the court, and the matter is prosecuted by either a prosecutor if it's at the High Court or a clerk, of course, if it's at the magistrate's court. The defense counsel is the person who appears on behalf of the accused person. When this matter is brought before the court, a bail application many times is made for the accused person. A bail application is made in the event that the accused person is offered bail, then a fingerprint order is made. Once all of this occurs, the accused has to answer his charge by way of attending court, at which time the evidence will be brought up against him. In order for this evidence to be brought against the accused, the prosecutor has to call witnesses to ground this case in law. The most important part of this process is the witnesses have to be available. Therefore, the complainant who is making the claim has to be available. The investigating officer who has investigated the matter, who has made a statement, and the complainant has also made a statement. In addition, if there's expert evidence needed, that person has to be available. And that expert normally comes from the Forensic Science Department, which is the government forensic lab. And in that case, you have many persons as the ballistic report, the toxicology, the crime scene investigation. All those persons have to be available to support the evidence because there are various forms of evidence. There's in circumstances, if a firearm is involved, the firearm has to be made available. And if there are documents, they have to be made available. The challenge is if when these statements are secured by the prosecution or the ability not to secure these statements, what then happens is the Crown, the prosecutor, the state, they are all unable to secure the evidence. And the challenge is when they are unable to secure the evidence, it is difficult or somewhat impossible for the matter to proceed. At that point, the court has a discretion. If after many mentioned dates, the case file is still not complete, the complainant is unable to be found, the documents are unable to be produced, the physical evidence is unable to be produced, the court has a discretion at that juncture to adjourn the case, sine die. So to pause the case hasn't been completed, to adjourn the case, sine die. Now, what is the challenge at this point? The challenge at this point is that the accused person is gone home, thinking the case has done, everything is great, and think there's peace and safety until one day now there's a problem. Sometimes they meet and they fall in love with someone or want to get married, or they're, they have long lost kids or their kids have migrated, and whether for whatever reason, whether they have gotten married or their kids have decided that they want them to become a family again, they then want to sponsor them for them to migrate. Not a problem. And many times these persons, just picked few countries want to migrate either to the United Kingdom, United States, or Canada. But in order to do so, one of the requirements if someone is sponsoring you is that you need a police record. So you get in your car and you take the bus or you find your way down and to get your police record. First, you have to visit the Inland Revenue Department at the tax office and you pay the fee. Then you go off to 56 Duke Street, downtown Kingston, to the records office of the Jamaica Constabulary Force. And right away, a light bulb appears in your head and you say, wow, I just remember when I was admitted to bail at court, my fingerprints were taken. And the information from the fingerprints are now sent to the Criminal Records Office. And there, all of that information is contained at the Criminal Records Office, because when an accused is brought before the court, once they're arrested, they're charged for either a summary offense or an indictable offense, a criminal record is created. But remember, your case never done, because remember, your case has been adjourned sine die. So what do you have to do? And at this point, you want to get married, or even in some instances, there are certain forms of employment in which you need a police record. So you're now in a little pickle because your employment situation hangs on a thread and your ability to migrate. So you now need a clean police record. What then you do? You need then the services of an attorney. Either you attend the Norman Manley Law School Legal Aid Clinic, or you attend an attorney in order for this attorney to bring the matter back before the court, so you can have a complete final disposing of your matter. This also is in the situation, the same procedure. If the Crown intends to discontinue proceedings on a nolle prosecute, your case, your records haven't been, your prints haven't been taken, is still at the records office. So council now has a very simple procedure, but a difficult task. Why is this difficult? Because council has to make an application for the case to dismiss and an affidavit to support that application. And this is a note for attorneys and law students. Why it can be difficult. One must ensure that when a matter is adjourned sine die, or the Crown enters a nolle prosecute, you have all the information as to that particular matter. Name of the parish court judge, if it's sine die, nolle prosecute, name of the high court or whatever court it is. The courtroom number is important, the clerk, the prosecutor, the name of the investigating officer, the offense, and the date when the matter was dismissed, sine die, or a nolle prosecute was entered. Why? Because once the attorney makes the application to have the matter brought back before the court will now have to look up in its records to find the court diary, to find the day the matter was addressed in order to bring it back on the court list. In the event all of this pertinent information has not been kept, it will be a challenge. So if it happened 5 years ago, 7 years ago, 8 years ago, you know, we have learned to keep matters for 7 years, but I advise all my students, especially the ones who intend to practice at the criminal bar, have a folder on your device, have a notebook of just different years and have a place that you keep it, because many times your client finds you. And then, you know, in the era of technology, it's very easy to find back a lawyer, and they'll always remember that you represented them and they were able to walk away from their matter, not maybe recognizing and appreciating that when your records are taken, when your prints are taken, a record is made, and unless the matter is formally completed, then the records are, your prints are still at the criminal records office. So I urge my colleagues and I urge students who are going to practice at the criminal bar, in the event that you have a matter that has been adjourned sine die or a nolle prosecute has been entered, please, please, please ensure that you bring it back before the court in a reasonable time so that time has not elapsed, and then you'll have the challenge of finding the court diary. Now, the slight possibility, and it's slight, that when the matter is brought back before the court, sine die, there is the possibility that the witness has now been located. The witness, the complainant, maybe migrated, and the older she has gotten or he has gotten, so, you know, this thing happened, they went to counseling, for example, if it's a rape matter, they went to counseling and they recognized through counseling that they have challenges in having a relationship based on the situation that happened, you know, in Jamaica. And, you know, they think they really want to come back to Jamaica to see if they can, if the matter is completed, if they can put closure on that aspect of their experience in life. So when a matter is dismissed sine die, it can be reopened because the complainant may decide, if that is what caused the matter to be adjourned sine die, that they want the matter to be completed, or for whatever reason, the documents that couldn't be located has been located. But more times than not, when the matter is dismissed sine die and it's brought back before the court, the person is the accused person is in a position to get a clean record. So the court will have to locate the material as I indicated, and the matter can be brought back before the court for the matter to be properly dismissed. Once you receive this information, because then you go, once the matter is properly dismissed, then you wait about a day or two and your counsel will go to the court's office for a letter stating that the matter has been dismissed. And then you can return back to 56 Duke Street to the criminal records office. And at that point, your case done now. Thank you very much for your attention. And I hoped I was able to shed some light on how a matter that appears to be finished, which has not been finished, can finally be completed. Thank you.
Thank you very much, Dionne. They did ask me, not they, one student asked me to ask, what are the most common matters that are adjourned sine die?
Sexual offenses. Because many times, I don't know if many persons had the privilege and opportunity to listen to King's Counsel Jeremy Taylor yesterday, in which he indicated that the matters that the sexual offenses matters many times are committed between persons who know each other, whether it be relatives, whether it be boyfriend, girlfriend, meaning the girlfriend is a little younger, the boyfriend a little older, or persons who they know. So many of those offenses are sexual offenses.
Thank you, Ms. Cruickshank. We're just giving the listeners a few more minutes to pose their questions in the chat.
Yes, and once a person's fingerprints are taken, there is a record. And whether your matter has been adjourned sine die, nolle prosequi has been entered, or you have been acquitted, it is important to visit the records office to ensure that that information is right.
One other question. You mentioned that certain information should be retained by counsel for the accused so that at a later date, the matter may be called up, because the court may need to refer to their diary. If it is that the diary cannot be found and one or more information cannot be obtained, for example, the name of the investigating officer or the date that the matter was dismissed sine die, what steps can be taken?
That is a very good question. But however, for example, the investigating officer, the station that would have charged the person would be the first port of call that I would attend to see if I can find, the whereabouts of the investigating officer, or many times there'll be somebody, whether at the station. I've been practicing, as you said, for the time I've been practicing, and I can still go to St. Andrew South, otherwise call Hunts Bay, or St. Andrew North, Constant Spring, or St. Catharines Central, which is Greater Portmore, also known as 100 Man, and still find people that have been there for years. So there are ways in which you can find persons who can assist you and who can, there are normally records which would have had the station diary, which would have had the person been in custody, or even the investigator, even if they weren't in custody, would have, the complainant would have come to the station and made a report. The council would have to do some background work in order to assist the court in finding this information.
Thank you, Dionne. There are no more questions at this time.
Okay, thank you. And it was a pleasure. And if anyone has any questions, they can feel free to contact me at the Norman Manley Law School Legal Aid Clinic.
We do have a student who would like to give the vote of thanks. So I now invite the student to please give our thanks to Ms. Cruickshank.
It appears that we're having a technical glitch. So at this juncture, I thank you again, Council, for inviting me to do this presentation.
Right, on behalf of the Norman Manley Law School Legal Aid Clinic and our listening audience, thank you, Ms. Cruickshank, for your very, very informative presentation. We benefited greatly. We don't think that our matters being adjourned, sign and die is the best position for us to be in unless we have counsel that is knowledgeable like you. We don't want to wait until we need to go abroad to get our matters relisted. So thank you so much for that. And for listening. And for a listening audience, the next segment of the Legal Aid Clinic Fair resumes at 11 a.m. And for further information, please visit our website at nmls.edu.jm or email us at nmls.lac@uemona.edu.jm. You may also reach us by WhatsApp 876-561-9803. Thank you so much, and we look forward to you rejoining us for our next segment of the Legal Aid Clinic Fair. Thank you, Dionne.
Thank you.